Good afternoon, Advocate Müter.
Good afternoon, Chief Justice.
You may take off your mask because I think there is sufficient distance.
Thank you.
Will you confirm whether, yeah, I see I didn't pronounce your surname correctly, did I?
It is actually Holland-Müter, but I'm used to it that people pronounce it in different ways.
But the correct way is Müter.
Holland-Müter.
Holland-Müter, yes. Thank you. How are you this afternoon?
Nervous, but well.
Yes. Thank you very much for availing yourself to be considered for possible appointment to the bench in Limpopo. We appreciate it very much.
Thank you.
Chief Justice? Oh, I'm
Yes.
sorry.
Before we proceed, I'm going to allow Commissioner Pillay to say something. She has something to say. Yes.
I'm not sure, does this happen in front of the candidate or not, Chief Justice?
Oh, well, because you are not going to leave us, maybe you can. Yeah.
Should I just go ahead?
Yeah,
All right.
because you leave us. Yeah.
Okay. Chief Justice, I just want to raise that I may be potentially conflicted in relation to these candidates in this batch because I represented one of the candidates in a disciplinary infraction we had with the bar. So I think it's probably proper that I withdraw from this section of the interviews.
Yes. She has discussed it with me. She's represented one of the candidates, and the matter is such that she believes it might come up here. And obviously, if she can't sit in regard to that candidate, she can't sit in regard to the rest of the candidates. Okay. Thank you.
Thank you, Chief
I think
Justice.
some of us envy you for having this afternoon off.
Lucky her.
Okay. We will then start now. Advocate Holland-Müter, you obtained your B.Juris degree from the University of Pretoria in 1978, is that correct?
That's correct.
And you obtained your LLB from UNISA in 1993, is that correct?
That is also correct.
Yes. And you then worked as a clerk in the Department of Justice from 1975 to 1978. And you did national service in 1979 to 1980. You were then a prosecutor from 1981 to 1982. You were a magistrate from 1982 to 1988. And you were a law lecturer at the Department of Justice College from 1988 to 1998. Is that right?
That's correct.
Yes. And you joined the Society of Advocates in Pretoria in 1998. Is that correct?
That is correct as well.
And you have been in practice as an advocate and as a member of that society since then.
That's correct.
Yes. And you obtained Silk in 2018.
I was nominated in 2018, but it was confirmed in August 2019.
Yes. That was like 10 years after you started practice as an advocate? 10, 11 years?
16 years, more
16
or less.
years.
Yes.
Oh, okay. tell us about your practice as an advocate at the Pretoria Bar. What branches of law are involved in cases that you have been doing?
Chief Justice, if I may refer myself as a general practitioner, medical-wise, excluding tax matters, I did about everything. I did criminal law, I did civil law, personal injuries, insolvency, company law, so the wide spectrum.
Yes. And have you still been doing criminal matters in recent years, or did that cease to be part of your practice after you had attained a certain level of seniority?
No, I still do from time to time criminal law, particularly when representing people in unlawful arrests. So yeah, but the criminal law has became a lot less as the practice grew.
Yes. When you were a magistrate, which was for about, was it about 10 years? 8 years?
It was actually from 1992 to 1997, 82 to 87. It was about five and a half years.
Yes, okay.
And the predominant layoff was in the civil court. My head of the office thought it well when there was a vacancy to transfer me straight into the civil court.
Yes. So you say your practice is basically a general practice?
Yes.
Yes. And you have acted in the High Court?
Yes, I started in 2015. Up until January this year, it totals up to around about 78, 79 weeks.
About 78, 79 weeks?
Yes.
Yeah, so that's quite a lot of acting.
Yes.
Yes. Now, what can you tell the commissioners that would reflect that you embrace the values of the Constitution?
Chief Justice,
about yourself and what you do and whatever. What can you tell them? Because one of the criteria that they look at is whether candidates are people who subscribe to the values of the Constitution.
well, if you have my nomination letter by my esteemed colleague Mpaga SC, who's now the chair of the Tshwane Society of Advocates, you will see that even around about 1988, when he came to the Justice College as a second-year student, so one of the first black students which were allowed there on the B.Juris course, that I embraced him and I made it for him. I accepted him and helped him to go through the system, where it was a predominantly white male dominion there at the Justice College. So from there on, I made it my task to see to that everyone is treated equally, irrespective of color, irrespective of race, irrespective of creed. He also states that in 1993-4, after he completed his studies, I was the instigator, if I may call it like that, who headhunted him for the Justice College to become the second black lecturer at the Justice College. The first lecturer was, he's now a judge in the Eastern Cape, the Honorable Tokota. He came a year before Mpaga to the Justice College, and we were since then close friends. And ever since then, I made it my task to see to, because that was part of the oath which we took as magistrate, is to see that the law is equally applied to everybody in the country. And I know one of the questions may be is that my pre-constitutional situation, have I not been contaminated by that? I can unequivocally say no. If I take where I come from, rather humble beginnings, My mom was a single parent as the year after I left school, and I worked during my school vacations to assist with my school fees, etc. I tried to make a difference. Like I set out in my application, like Mpaga states it, and when we were together on the Pretoria Bar Council, where I served for 10 years. Now, the Bar Council since 26 in Pretoria consisted of 50-50 management between AFT and non-AFT. And more than once, on most occasions, it was basically blocks votes against one another. And Mpaga vouched for that in many instances, I played a reconciliatory role to get the two parties together in the interest of the bar. One of the aspects, and one of our former chair is now Judge Norman Davis in Pretoria, we were from the people who made it our mission to fight to expand our pupillage at the Pretoria Bar for especially students from previously disadvantaged backgrounds. And we started gradually to increase our black students and colored students and decrease white students or pupils because it is, in my view, a constitutional imperative that we make it as open as possible for all candidates. Then, as a member of the Pretoria Bar, one of my tasks was to sit on the I was the chairperson of the personnel committee, and when people applied for membership at the Pretoria Bar, to screen them and to interview. And in that, I went to great lengths to make it possible for previously disadvantaged members to join the Pretoria Bar. With the bursary applications, which I've done, I did it now in January again for the bar. I've done it for the past 14 years. To investigate whether it is possible to assist almost every previously disadvantaged student, pupil to be assisted by the general bar. Because in my view, and there are at this stage people like Advocate Manala, Advocate Tipe in Polokwane, who would not have made it if it was not, and I don't want to pat on my shoulder, but for the efforts which I made to have them qualify for bursary applications so that they continue with the pupillage. So I made it that. Apart from that, you would have seen in my application the role I played in the transformation of a white primary school in a predominant white area to a dual medium, and it's now an English medium, with about 90% of the students, which are black students, coming from Mamelodi and Eersterust. Because there's facilities which can be used for these people who don't have it in the townships. Why must we hide that? I was not the favorite of many people in my community, but that was my conviction, to open up the facilities of Rietfontein North, to transform it from a white small school with about 250 pupils, where it is now in excess of 800, of which 90% are black pupils. So all along, it's been my mission to see there that we can assist people and uplift the people of this country. I don't know if you want to know anything else, you're welcome to ask me.
Yeah, no, just the important ones.
Yes.
Yes. And how many written judgments have you produced, more or less? You don't have to be exact, as an acting judge in the High Court.
Reserved judgments, there's a list which I mailed, and I assume the...
Not reserved, written judgments that you have produced as an acting judge.
Well, the last time I acted, now in January, I was in it was in the unopposed court, so there was not one. But in 2021, at least 5 to 6 judgments which were reserved, which I, within 3 to 4 weeks, completed, and that was handed down. So, yeah, quite often, if you sit in the post-motion courts, about at least 50% of your motions applications, you reserve judgment and you give a judgment in 2 to 3 weeks' time from that. It's difficult for me to say, and I don't, please explain to me what you mean by recent.
No, I didn't say recent, I said written.
Written.
Yes.
Well, there's 59 written judgments,
Yeah.
which are reserved, yeah.
Yes, okay, no, that's fine. And when you have acted, obviously, having acted so many weeks, you would have sat in full bench appeals, you
Yes.
have done a lot of motion court, you would have done, I guess, a lot of civil trials as well. Is that correct?
That is correct.
And you would have sat in some criminal matters as well?
I did one full term in Johannesburg in 2019, where I did 3 full trials, murder trials, but I sat in criminal appeals and full court appeals a number of times.
Yes.
The only aspect which the JPF Pretoria did not use me for is for tax court applications or missions.
Yes. And in motion court, did you have occasion to deal with matters where you were asked to declare some legislation unconstitutional?
No, but I was involved in matters where constitutional issues were raised. I remember the one matter in 2020, it was between Solidarity and the Minister of Tourism, which I granted a temporary interdict because, in my view, the publication of the notification was in terms of Section 9 and not Section 10 of the BBBEE Act, and it stopped about 2 billion rands of funds to be distributed before it could be proper heard by a full court. In my view, the wrong vehicle was used in declaring that system available to people. So no, I haven't had opportunity to declare or to refer matters to the Constitutional Court for invalidity, but I've worked with issues where matters where constitutional issues were raised.
Does that apply also when, in terms of matters in your practice, namely, you haven't had matters in your practice too, apart from those that you may have come across as an acting judge? So in your practice, you also didn't get those matters?
I was involved in one matter in the Constitutional Court, part of a team where the Jager SC was my leader, and it was about the consolidation of Department of Justice Acts after the new dispensation came about. It's reported as S versus Tunzi, 2009. In the Concord. It originated from the Eastern Cape because it was about dangerous weapons. In certain jurisdictions, there was specific legislation, in others, there were not. And there was a constitutional issue which was raised in the Eastern Cape, and De Jager and myself were briefed by the Department of Justice to act on their behalf. And I had to, for my leader, I had to investigate all the publications in the former republics or Botswana and all these, where some of them just took over the existing legislation from the then RSA. In Venda specifically, it wasn't done. So there was a difficulty with regard to the application of minimum sentences with regard to dangerous weapons at that stage. So yes, I was involved in a practice in that instance.
And have some of your judgments that you have produced during your acting stints been reported?
Yes. In my application, there is a list.
Yes.
I can also say that only 2 of my judgments were reversed by the Supreme Court of Appeal. One was in my first stint in 2015, and one was in 2020. But all the others, the SCA confirmed, and all the petitions were refused, where I refused to grant leave to appeal.
And are there any cases in which you appeared as counsel which have resulted in reported judgments?
Yeah, yes.
Yes.
In 2005, there was 2005 or 2007 of Van der Merwe versus the RAF. It was about section 17.4 of the Act with regard to the claims of medical supplies, whether they can go straight forward to the fund or where they have to issue. It was reported. Then there was a matter reported. The late Judge Patel was the presiding judge. It was a murder case on the Circuit Court in Middelburg. And then there was a matter not recently, in which the SCA confirmed it of Patel versus the RAF. So yes, the list is in my application.
Yes.
May I just say that the recommendations made by Mkari SC on behalf of the Polokwane Society, on the last page he lists 7 judgments. It purports to be judgments which I gave. It's only 2 is mine. 5 are from the Western Cape, and I never gave judgments in the Western Cape. So I just want to let the Commission know that you take note of that, that probably he just got it mixed up.
Yes. Okay. I'm now going to give the opportunity to the Judge President to ask you questions. Judge President, I just mentioned, Judge President, that we have agreed to limit the commissioners to 2 questions, but I give the Judge President more leeway because it's your division and you know the needs of your division. So I'll give you some more leeway in asking questions.
Thank you, Chief Justice. Good afternoon, Mr. Holland-Müter.
Good afternoon,
Thank you.
Judge President.
Is it so that you did avail yourself for interview by this commission in respect of Gauteng?
In the past, yes.
In the past, what was it, October 2021?
October 21 and also October 2019.
So on 2 occasions?
2 occasions.
All right. Right. Now, I would like to have your comment with regard to what the Limpopo Society of Advocates say in respect of your candidature. In fact, they do recognize your experience as counsel and also as an acting judge, of which I also share their view in that regard, your experience. But what they are concerned about is the following. They say the candidate is 65 years old, which is not an ideal age to go to the bench because the appropriate retirement age is 70 years of age to the maximum of 75 years, which by any standard is an overstretch. The candidate's age should count against his permanent appointment to the bench. An opportunity should be given to the young and middle-aged candidates who still have more to offer to the judiciary and the country. Before you answer that, you'll recall that early this year, after you made yourself available, you did approach my office to introduce yourself, as you did not in the past act in Limpopo Division. I also raised the same concerns about that. Now, what's your comment on this issue?
Judge President, and if I can refer to what the esteemed Deputy Judge President Roland Sutherland said during his interview when he was appointed at the age of 70, that age of 70 is a number. If we look at 70, 20 or 50 years ago, it was a total different aspect. We have it that in our generation, especially in the professional field, jurists, medical doctors, architects, etc., that they go far beyond the age of 65. In many instances, people reach maturity when they in their mid-60s or early 70s. So I can't see that as a factor to be a negative factor in my view. I may just add that in terms of the Judges' Remuneration and Conditions of Employment Act, there's provision there for that a person can stay on until the age of 75. There are certain limitations with regard to your remuneration afterwards and your gratuity, and there are formulas built into that. But if the legislator deemed it, in my view, that it is not fit to proceed beyond 70, then they would have had another provisions in the Act. So no, in my view, there's nothing wrong with me. With my vast experience, I think I can play a very, very meaningful role there in your division.
Thank you. That will be all, Chief Justice.
Thank you. Advocate Singh, I give you the opportunity.
Thank you very much, Chief Justice. Good afternoon, Advocate Holland-Müter.
Good afternoon.
I too want to refer to some of the comments submitted to the JSC by Nadel. There's two comments I want to put to you, and the first one I'll put to you as information. The second one I'll require a response for. The first one is at 18.4 or 184. It says the applicant has also displayed his commitment to serving the community by offering legal services on behalf of indigent clients and rehabilitating formerly incarcerated individuals, which is commendable. No, I don't need to comment on it. I was just putting that to you. However, at 185, they go further to say, although Advocate Müter SC, as a legal practitioner, has a wide range of experience as an advocate, senior advocate, and acting judge, we do, however, believe that his appointment will not help in balancing the demographics and representativity in this particular division. Perhaps your comment on that, on that remark.
You want on what the 185?
Yes, 185.
On 185, it is so that in appointments, the racial demarcation, demographics must be taken into consideration. And unfortunately, I cannot change the fact that I'm a white male. But it needs to be balanced that my vast experience and what I can, the role which I can play in the next, if I'm appointed 8 to 9 years there, that should not be just, as they say, with the water being thrown out of the door. If we look at the Limpopo province, then if you want to apply it strictly with the greatest respect, then at the moment there are no colored or Indian judges appointed there. So it is, in my view, necessary to balance it countrywide. Because in the Western Cape, you will there have more people of color. In KwaZulu-Natal, you will have more people of Indian origin as judges. So all in all, I think it should be a balanced situation, and that I take notice of that with respect. I don't deem it that it should bar me for being appointed. Are you satisfied? Anything else?
No, I'm satisfied, Advocate Müter. Thank you very much. Thank you, Chief Justice.
Thank you. Commissioners, Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon, Advocate Holland.
Good afternoon.
One sing following another.
We will sing along then.
No, then everybody will leave. One of the criteria that's listed that we consider, and I'll read it to you, is the proposed appointee an experienced person? Right. A is technically experienced, which certainly you are. B, experienced in regard to values and needs of the community. Now, I would just like to know, what are your links to the Limpopo community? Because you're born in Gauteng, you've applied in the Gauteng bench. What can you say about your links there that can convince us that, yes, you will associate yourselves with the values and needs of that particular community? Thank you.
I don't have direct links with the Limpopo community, but the links which I have in Gauteng, in Pretoria. Those are links which you can transfer. That is my involvement, particularly with old age homes, with at the moment the Jacaranda Children's Home where I'm involved. They have in Nelstroom, Modimolle, there is also Abram Kriel house for discarded youth, and I can just shift my involvement from the Jacaranda Children's Home to the one in Modimolle, which is basically the same organization.
Just to follow up, have you had any other social interaction where you are with communities, NGOs, etc.?
In my community?
Correct.
Yes, I have. In our congregation in Valeria, we have what is called, specifically the Echo Youth Development. It is a non-profit organization under the umbrella of our church. It was started 16 years ago by Pastor Jaco Strydom, who started with one house. There are at the moment 15 houses, of which 5 is in our community. The furthest is in Cape Town. In our community in Valeria, we have 84 kids, of which about 75% are black kids, which are housed in this. Some of them are still school going, some of them are youth just out of school, but which are to be rehabilitated and to be helped into the society. One of our black girls, about 7 years ago, she was in matric in Oostmoed High School in our proximity. But she comes out of a very, very sad background. And her parents could not afford her further education. And by means of bursaries, which Echo Youth Development procured, she completed the studies at the University of Potchefstroom, and in her third year, she ended up on the student council there. So, yeah, we do that. My involvement is specifically at House 15 of the 20. There are 20 houses in the Jacaranda Children's Home in Eastland and Pretoria. My wife and myself, we are the representatives of our church in House 15. We were there yesterday afternoon, and 7 of the 12 boys in our house are black. So we want to see that these kids, when they reach the age of 18 and they can no longer stay there, that they just don't go out back to the gutters. The one guy, a chap who's a matriculant at the FH Oudendal School.
Sorry, Chief Justice. Through you now, thank you very much. I think
Yes.
you've convinced me. But will I be correct in saying that you do not have any direct links with the community of Limpopo?
No.
But you have links by association?
By association.
Okay,
And I may just say is that by association also with some of the council in Limpopo. And as what I'm doing at the moment in Pretoria, I can also become involved there in the training, ongoing training of pupils there at the Limpopo bar.
Thank you, Chief Justice, and thank you.
Thank you. I'll go to the commissioners who are attending virtually in the meantime, because I don't see any hand. Yeah, okay. Okay, but I'll go to the commissioners attending virtually in the meantime. Anyone who has a question, commissioners? Commissioner Barnett, do you have a question?
Yes, I have no questions, Chief Justice.
You have no question, thank you.
No questions, Sir.
No question, thank you. Okay, Justice Spitzer.
Thank you, Chief Justice. Good afternoon, Mr. Holland-Müter.
Good afternoon, Commissioner.
I'm having in front of me comments from the Limpopo Society of Advocates, and it is paragraph 51.3 that I want to focus on.
Paragraph?
51.3.
Thank you. Yes, I'm there.
Which reads thus, Furthermore, the candidate does not appear to have attempted in his application and subsequent interview to engage in detail with his involvement in the apartheid criminal justice system and how it may have influenced his outlook of the country and its people as a judicial officer. And my question to you is, could you please enlighten the members of this commission as to what your judicial philosophy is?
Thank you. Can I just say, if you look at the paragraph, it refers to a subsequent interview. I think that is a printing error because this is the interview after my application. There was not an interview in between. So I had difficulties to see my application and subsequent interview. I don't know if you follow me.
Could you
But I can...
Could you simply just respond directly to the question? And
Yes,
leave
I
it at
can.
that? Thank you.
My attitude towards the judiciary is that as any magistrate or judge who takes the oath, that you will apply justice to every person before you, influenced by color, race, creed, or gender. My philosophy has always been is that the person who stands there must, whether I represent him or whether I'm a judge or whether I was a magistrate, he must receive the best possible legal assistance. And if, as a judge, there must be justice. It has to be seen to be done towards that person. I am adamant that I was not contaminated in the pre-constitutional situation as a prosecutor. I know that there are instances where magistrates and prosecutors travel together to periodical courts or regional courts. I never did that because I felt it was wrong that you must separate it there on the lowest level. So my attitude is, no, you have to be equally fair to each person.
Thank you, Mr. Holland-Müter. I'll leave it at that.
Thank you.
Thank you, Chief Justice.
Thank you. I didn't see any other hand. Commissioner Mapisa Ngakula.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Good afternoon. Advocate Holland-Müter. Advocate, and please bear with me. I'm not trying to.
Don't be too far from your mic.
Oh, sorry. I'm not trying to. I'm not wanting to dig deep or trying to open wounds of the past unnecessarily. But I am interested to know, because from what I have read here, I've read that you were a prosecutor during the period
1981-82.
19 years. I'll be interested in the nature of the cases you were dealing with.
Well, I was a prosecutor in the district court, and the normal cases we heard there was the normal shoplifting, assault cases, etc., etc. In the early 80s, when there was unrest starting to, those cases were heard in the regional court. I wasn't a regional court magistrate, prosecutor, so no. I was not involved as a prosecutor in any matter which can be related to previous unrest under those circumstances, no. It was normal cases, shoplifting, theft, housebreaking, etc., which is normal in the magistrate court.
Okay, thank you very much. Then there is somewhere here. I'm sorry, CJ, because the bundle which I have here is very confusing as compared to what I had earlier on, where I have 7.1, which
Was that on the questionnaire?
on the. I think somebody was trying to summarize what is in the questionnaire, or maybe minutes of the last meeting, I don't know. But it talks to the extent and breadth of the candidate's professional experience. Then it goes on to say, the candidate, however, indicated in answer to question 5 of the JSC's questionnaire that he only acquired his B-Proc qualification in 1988, 3 years after he claims to have been employed as an appointed prosecutor.
No, I never obtained a B-Proc degree. I obtained a B Juris in 1978 and then my LLB in 1993.
Okay. Can you
Is it
please?
possible you might have confusing it with another candidate?
No, not at all.
Oh,
This is, yes, Advocate H.L. Müter.
okay.
And then it goes on to say, as a prosecutor requires a law degree as a minimum qualification, and as the candidate did not have such a qualification in 1981 to 1985, it is unlikely that the candidate was appointed as prosecutor during that period. What I am reading here is what is written in this file. So, and therefore, the candidate's work experience for the period between 1981 and 1985 is accordingly disregarded for the purpose of assessing the candidate's relevant experience, and he ought to be given the opportunity to clarify this apparent contradiction.
That's with the greatest respect wrong. The qualification in those days to be a prosecutor and or magistrate was a B Juris or Diploma Juris qualification. I had my B Juris, which I obtained at the end of 1978, so I was qualified in terms of the Magistrate Court Act to be a prosecutor, in terms of the Criminal Procedure Act and in terms of the Magistrate Court Act to be a magistrate. That was the minimum qualification, and I had it since 1978.
Okay. Thank you very much, Mr. Chair. Thank you.
Thank you. Judge President Lekodi will ask a follow-up question.
I think somehow the commissioner spoke about unraveling the healed wounds of the past. And you are aware that 85 and 86, everything was on fire. First, because of the first state of emergency in 1985, and the total state of emergency in 1986. And if I understand you correctly, you were a prosecutor at that time, am I right?
No, I was a prosecutor 81 to 82, and at the end of 82, my head of office made me the civil magistrate until 87 when I left for the Justice College.
Okay, let me put it differently this way. 81, 82, there were still lots of public violence matters, am I right?
Yes, you're right.
And I understood you to be saying at that time you had nothing to do with those matters because they were tried in the regional court.
That is correct.
But their first appearance would have been in the district court, and I'm talking from experience. In those circumstances, the district court public prosecutor will oppose the release of those people on bail with force. Would I be right?
That is right. If there were reasonable grounds to oppose their release, it would have been done. But I recall none of those which I dealt with. I was not involved in that.
Yes, but your problem is that you're saying, as far as the public violence matters were concerned, you had absolutely nothing to do with them because they were tried in the regional court.
Yeah, but if I can, sorry?
Yes, you may proceed.
If I can say that in Witbank we had 3 district courts. So the cases which appeared there and which were clearly earmarked to go to the regional court, they were, at that stage, you had to obtain a regional court date within 1 to 2 months. The matter would come back to your court as an ordinary prosecutor maybe once or twice, and then it's referred. If there were applications for bail and so on, there would have been formal bail applications or applications to release, and I can unequivocally say I was never involved in such an application.
Okay, thank you. I wanted to make a follow-up, but I'm not going to do that.
Okay, thank you. Commissioner Baloyi.
Thank you, Chair. Thank you. Thank you, CJ. Good afternoon, Mr.
Good
Mayor.
afternoon, Commissioner.
Yes. You became a member of the Pretoria Bar in 1998.
That's correct.
And you were called to Silk in 2019.
Yes.
Right? And yet you say you had only one pupil.
No. I had 4 pupils while I was an ordinary member.
Well, you mentioned a pupil. You don't, I've looked at your application, and I'm trying to find that page. You mentioned only one pupil.
On what page is that? Because,
But anyway, you say you had 4,
yes, I had 4 pupils.
and that is 4 in 18 years that you were at the bar.
The situation is that when I became a member of the Bar Council, you were relieved of that duty and of the training committee because you were daily involved in the training of all the pupils. So they allocated the new pupils to council who were not on the Bar Council or on the training committee.
So you were on the bar council for how long?
10 years. And I was on the training committee since 2005, so it was about 4 or 5 years after I joined the bar.
Okay. Now, you've got a letter of support here from Mr. Mpacha. Now, Mr. Mpacha is no longer a member of the Pretoria Bar, right?
He's the Tshwane Society of Advocates.
Yeah, and how does that come about, that Society of Advocates?
The Tshwane. They
Yes.
broke away during the national lockdown towards the end of 2019, beginning of 2020. There was turbulence in the Pretoria Bar with regard to the lease agreement of the office in town. And they were a group who went to the east where they formed a new society.
What is the racial demographic of that group?
Of that
left?
group,
Yes.
it's basically, but for one, it's a black group.
So black members left the Pretoria Bar to go and set up somewhere else.
Some of the black members, yes.
And the reasons were what?
The reasons was because there were difficulties between some of the other buildings and High Court chambers in town about the lease agreement which existed there. It left, with all the groups who had previously left to the east, it left High Court chambers with a burden of empty chambers, a long-term lease, and most of the junior blacks who remained behind. And you will read further that I refused to move to the east because I said somebody has to stay in town with these young black council. They need to have, and we were 3 silks who stayed behind up until when the lease agreement was finally terminated.
So if you do get appointed, in fact, you're saying these black juniors will now be left without your support?
Well, the lease agreement has been terminated with the lessor, so there's no longer lease. They have vacated the building at the end of February, and they are now in other buildings.
Okay. And we know now, and I raise this because you do speak to it, and not everybody in the room understands the politics of the bar. There was, at least let me say, in Johannesburg we still have, but in Pretoria as well, you had the co-governance model,
Yes.
where you had 50% AFT, Advocates for Transformation, and you had what we call the main bar, right? And the Advocates for Transformation were overwhelmingly black members.
Yes.
You accept that? Okay. What has happened to that co-governance arrangement?
The co-arrangement came to an end of 2021, middle of 2021,
Yes.
when the majority of the bar, I was not present there because I didn't want to go to such a meeting. The constitution was amended, making provision for new buildings which were created in the east, and the termination of the High Court lease. And then the whole restructure took place. There are still people in what is called New Court Chambers, which is adjacent to where High Court Chambers is, which is predominantly black.
Okay. Can I just ask you, just to assist the members who are not members of the bar, what is the co-governance model? What is its purpose? What was its purpose?
The purpose was of co-governance of 50-50, because at that stage, when it came about around about 2007, after the then chairperson of the GCB, Norman Arends, met us at the general meeting, it is to enhance the black the young black, because they were far in the minority. And transformation would not play a role if you have a governance by a simple majority, because they will every time be voted out. And that is why it was part and parcel, and I fought for that with Davis, the Honourable Judge now, and with the previous chairperson, Francois Botha. We fought to have this 50-50 governance, as suggested by Norman Arendse, so that we can protect the interest of a minority group.
Yes, and now that protection is no longer there.
That protection, unfortunately, is no longer there, but they have a similar protection in the new constitution, where in each building, depending on how many chambers are there, they must have at least one non-white and one white representative representing each building. So in fact, it is basically still a 50-50 governance, but there's no longer a formal AFT in Pretoria.
Well, there is no...
Try and wrap it up.
I am wrapping up, Chair. There is no formal AFT, but the constitution of the Pretoria Society of Advocates
Guarantees
does not provide for a 50% AFT that represents overwhelmingly black advocates. That's what I'm establishing with you.
no longer, yes.
Yes.
You're correct.
And you didn't attend, you chose not to attend the meeting where the decision was made to collapse that 50-50% arrangement, because you didn't agree with it, but you made a decision not to attend.
Because they knew what my stance would be, but we were outvoted, and that is why it was a waste of time, and that is why I have alliances, although I'm not a former member of the Tshwane Society there where Mosampaga is, but I underwrite what they do.
All right, thank you, Mr. Holland. Thank you, Chief Justice.
Thank you. I don't see any other hands. I have already gone to the commissioners attending virtually. We have come to the end of this interview, Advocate Holland-Müter. Thank you once again for availing yourself. I will give you 3 minutes. If there are some points you want to particularly emphasize that you would like the commissioners to bear in mind when they consider your candidature. But if you feel that issues have been dealt with adequately, that is also fine.
Thank you, Chief Justice. I just want to say is that my track record is very clear, and Mpaga, my good friend, speaks about that, and my application speaks about that, is that where my heart lies with regard to transformation, with regard to the development of our country. If I can use the simple example which I normally use when I talk about this, if we take the Brazilian national soccer team, they are from lily white to dark black, but they're Brazilians, they're one team. And I pray for the day that when the Bafana goes onto the field, that they also have the support of the majority of people in this country who support rugby and not football. We took a hiding against the French last week. Percy Tau wasn't there, but it was a good learning experience for our guys. My heart is that I'm pro-transformation, that every person in this country, irrespective of color, race, gender, must have equal opportunities. But there are vulnerable groups, such as women, such as children, which needs extra protection. And that is what each and every one of us, judges, each and every commissioner, every person in this country has that obligation to see to that we protect the rights of these people who cannot stand up for themselves. And that is why I'm involved in the Jacaranda Children's Home, where we can try and make a difference in those castaway kids' life so that we can make them useful citizens of this country. As a judge, if I'm appointed, I can get involved, and I want to get involved at the Limpopo Society, like what we had before lockdown in Pretoria. From time to time, retired judges Bertelsmann, Cynthia Pretorius, once a month they held informal information sessions with counsel who wanted to attend it, and aspects of the practical implications of the court was discussed. That unfortunately died, something which can be revived. Thank you.
Thank you very much, Advocate Holland-Müter. you are now excused.
Thank you, Chief Justice, and all the commissioners. Best of luck for the rest of the evening.
Thank you very much.
I'm retiring, you're not. Some of will sing along. Thank you.
Thank you. Bye-bye.